Our topic for today's session is the recent Supreme Court decision of Fowler and HMRC. That's a case in which myself and Colm Kelly appeared. Colm is going to be joining me for this discussion today. The Fowler decision, as you know, concerned the employment and business profit articles of the UK-South Africa double tax convention. That tax convention is based on the OECD model convention, and therefore the principles to be derived from that decision are of more general application. In terms of our discussion this morning, I will first outline the model convention rules on income from employment and business profits. Colm will then discuss the background and context to the Fowler case. I'll then go through the Supreme Court decision, firstly identifying what I think are the points of general application to be derived from that judgment, and then secondly to look at how the Supreme Court approached and decided the treaty interpretation question in Fowler. And then Colm is going to look at the potential implications for other deeming provisions. Starting then with the OECD model convention, our basic scenario is a non-resident employee who exercises an employment in the UK from which he or she receives income. Article 15 of the OECD model allocates taxing rights to both the country of residence and the country in which the employment is exercised. Just to note that Article 15.2 does provide an exception from that, where the employee doesn't work more than 183 days in the UK, and importantly, his employer is non-resident, also non-resident. So just looking at Article 15, we can see that it provides that salaries, wages, and other similar remuneration derived by a resident of a contracting state in respect of employment shall be taxable only in that state unless the employment is exercised in the other contracting state. So we can see that the term employment is very important in this article, as the application of Article 15 is dependent on there being a relevant employment which is exercised in the other contracting state. So employment is not defined in the treaty, and so we have to look at Article 3.2 of the convention, the model convention, which addresses how one finds the meaning of undefined terms in the treaty. There are 4 points to note about Article 3.2. The first is that it provides that the domestic law will supply the definition for any undefined terms. Secondly, we can see that Article 3.2 is what is described as an always speaking provision, in the sense that it is the domestic law meaning at the time of application which is relevant, not that which was the meaning at the time the treaty was entered into. So if after the treaty was entered into there is a change of domestic definition, then it is that changed domestic definition that will supply the meaning of the undefined term. Third, where there is a conflict between the general domestic meaning and the domestic tax law meaning, it is the domestic tax law meaning that will supply the definition of the undefined terms. The fourth point to note is that the domestic tax law meaning or domestic meaning will not, however, supply the definition if the context otherwise requires. And Colm will address what that means and how that's interpreted in due course. The third relevant provision for the purposes of our discussion is Article 7.1. Article 7.1 allocates taxing rights in respect of business profits. And you can see that it does that by allocating taxing rights to the state of residence of the business, unless the enterprise carries on business in the other contracting state through a permanent establishment situated therein. Now, business profits and business may not seem like the obvious, or may not seem like it may obviously apply to individuals. However, Article 3.1d of the Model Convention provides that business includes performance of professional services and of other activities of an independent character. So it does cover services provided by an individual in a self-employed capacity. It was introduced, that change definition was introduced in 2000 following the deletion of the separate independent personal services article. Now, Article 7, therefore, as we can see, in respect of a self-employed individual, will allocate taxing rights solely to the country of residence unless those services are performed through a permanent establishment in the other country. Now, for an individual, how do you go about determining whether or not they have a permanent establishment? That is defined in Article 5, and that provides that if the individual provides services for more than 183 days in the other contracting state, then they will have a permanent establishment in that other contracting state. I'll hand over to Colm now.
Thank you, and good morning, everyone. So as Akash said, I'm going to take you through the factual background to Fowler and tell you how things went right up until the Supreme Court. So Mr. Fowler himself was a South African national and a South African resident. He wasn't dual resident in the UK. In terms of employment, he worked as a deep sea diver on the UK continental shelf, effectively carrying out repair works at great depth. His employment status wasn't actually determined in these proceedings, and it's still a live issue, but it was assumed for the purposes of this preliminary issue, which was litigated all the way up to the Supreme Court, that he was employed. And then we have the South Africa-UK double taxation agreement, and it incorporated the OECD articles that Akash has just taken you through. The only difference being that the employment income article was labelled Article 14 rather than 15, but otherwise the language for present purposes was the same. So based on what I've told you, you might wonder why there is an issue whatsoever. Mr. Fowler was assumed to be employed, and we can see what employment means for tax purposes domestically in Section 4 of ITIPA. I'm sure this will be familiar to most of you, but importantly, it includes employment under a contract of service, all the usual things you'd expect to see for the definition of employment. Going a little further on, again, this will be familiar to you. There's the basic charge on employment income, but importantly, in Section 6, there's subsection 5, which says employment income is not charged to tax under this part if it is within the charge to tax under Part 2 of ITOIA trading income by virtue of Section 15 of that Act, divers and diving supervisors. And so therein lies the rub. We go to Section 15, which everyone was agreed did apply to Mr. Fowler because he satisfied the three conditions you see in subsection 1, performing the duties of a diver or diving supervisor, and important to note, it's duties of employment, you'll see. The duties consist wholly or mainly of seabed diving activities, and any employment income would otherwise be taxed under Part 2 of ITIPA. All of those were satisfied. And then this is the key part, a deeming provision in subsection 2, which says the performance of the duties of employment is instead treated for income tax purposes as the carrying on of a trade in the United Kingdom. So there was an argument over what this meant in Mr. Fowler's case. What the taxpayer said was that this meant he was carrying on a deemed trade for all income tax purposes, and that meant that instead of being within the employment income article, he was in fact within the business profits article. His employment had been recharacterized as a trade. It had been deemed to be something other than what it was in the real world. So he was within Article 7 rather than Article 14, and therefore South Africa had taxing rights, not the UK. The Revenue disagreed and said that this article was only about how things were taxed. And by way of historical background, it said this was introduced in the 70s to deal with a shortage of deep sea divers who were actually willing to come to work in the UK. And it was designed to give them a more beneficial treatment in the way they were able to claim expenses. Even if they were employed, they were going to be treated as if they were self-employed for claiming expenses in effect. That was the factual background to the section. There were obviously statutory predecessors to Section 15 in Atoya. So in the FTT, the taxpayer succeeded. Then we play the game of ping pong, where the Revenue was successful on appeal in the upper tribunal before Mr. Justice Marcus Smith. Then in the Court of Appeal, the taxpayer was successful, but by a majority, where Lord Justices Henderson and Baker agreed with him, but Lord Justice Lewison agreed with the Revenue. And then the Revenue appealed to the Supreme Court. And that's what Akash is going to come on to talking about in a moment. But first, I'm going to pick up on one point that stayed in the upper tribunal and, although argued, never got a decision any higher up, which is that point Akash flagged. You'll recall that in Article 3.2, undefined terms are given the term that the domestic tax law of that state would give them, unless the context otherwise requires. And there was an argument over what that meant. The taxpayer's argument was that this had to be necessary. And it wasn't simply that it was going to be desirable or reasonable or anything lower than that. It was a very high standard. That argument was rejected by Marcus Smith, who said what you'll see quoted there in paragraph 34. And he's happy to disregard the domestic tax law meaning if it results in an outcome that is either not sensible or not reasonable. So a standard that's at least lower, maybe significantly lower than a test of necessity. Now, this point was argued in both the Court of Appeal and the Supreme Court, though decided by neither of them. So at the moment, Mr. Justice Marcus Smith's statement is the last word on the matter. So an interesting point for anyone who is considering whether or not they need to take themselves out of a domestic tax law, meaning when looking at Article 3.2. And so with that said, I think I'm going to hand back over to Akash to talk you through what the Supreme Court said and what you can derive from that.
So I'll start with the general principles that I think we can derive from the Supreme Court's judgment. The Supreme Court, perhaps surprisingly, given the difference of opinion in the courts and tribunals below, were unanimous. So it was a 5-0 verdict. The judgment was given by Lord Briggs. And first of all, he addressed what was a dispute between the parties in terms of the Revenue were relying on the OECD model commentary, some of which postdated the entering into force of the South Africa-UK DTC treaty. And the taxpayer was saying that that was inadmissible. The Supreme Court confirmed that it was permissible to rely on post-dated commentary, that commentary could be illuminating, and that it's the weight you give it depends on its cogency. So that was the first point of, I think, of general principle of wider application. The second was the Supreme Court's reliance on its earlier judgment in the case of Anson, and in particular paragraphs 110 and 111 of Anson. In those paragraphs, the Supreme Court had emphasised the fact that the treaty, or a treaty, should be construed not in a literalist manner, but rather in a manner which is international, not exclusively English. And the Supreme Court said that that broader approach recognises the fact that the UK is only one of the parties to the treaty, the terms of which reflect the intentions of both countries. And we'll see that the Supreme Court in Fowler, in considering whether the UK domestic deeming provision altered the treaty meaning, relied on the fact that they were interpreting a treaty and that this was a bilateral international agreement. The third point I wanted to just tease out as a general principle was the fact that the Supreme Court endorsed the approach to treaty interpretation of the Court of Appeal in Smallwood. Now, Smallwood was a case that I did with Tim Brennan now almost, well, 10 years ago. Gosh, time flies. Now, this is significant because the taxpayer was arguing that Smallwood and the Court of Appeal's guidance in Smallwood had been superseded by Anson, and that guidance in Smallwood shouldn't be applied, and that the court should only look at Anson. Significantly, Lord Briggs said that no, that Smallwood, the relevant passages in Smallwood at paragraphs 26 to 29 of Lord Justice Patton's judgment repays reading, and moreover, he said that paragraph 29 was worth quoting in full. And hopefully you see that there up on the slide. And the significant point to note from this passage is the fact that the Lord Justice Patton emphasised that when looking at the treaty is not concerned with how the particular state taxes a particular source of income. He noted that the purpose is rather simply to set out rules for resolving issues of double taxation, which arise from the tax treatment adopted by each country's domestic legislation, and that it's not the role of the court interpreting a double taxation treaty to get too bogged down in how the domestic or the contracting state taxes the particular source. The next point or next area that I think one can draw some more general application from is the Supreme Court's approach to deeming provisions. Lord Briggs, as you can imagine, considered all of the well-known cases such as Marshall and Kerr on deeming provisions, but he observed that the dicta in those authorities are not conclusive because, although not actually contradictory, they do tend to point in different directions. And indeed, when you look at this case and the way that the court or the decision has ping-ponged all the way up to the Supreme Court, I think it does show that there is something always for both sides in those authorities. Helpfully, Lord Briggs set out a 5 bullet point summary of the guidance in the authorities, which we put up on the slide. You'll note that the first point is the familiar starting point, that the extent of the deeming fiction is primarily a matter of construction of the statute in which it appears. The second point is important because what it does is it identifies a two-stage approach to interpreting and applying deeming provisions. First, it's important to identify the purpose of the deeming provision. And then secondly, having identified the purpose, to apply the relevant provision consistently with that purpose. The third point flags up the difficulty of applying that two-stage process in practice. And then you'll see the fourth point provides a limitation on the exercise. A deeming provision should not be applied so far as to produce unjust, absurd, or anomalous results unless the court is compelled to do so by clear language. However, then the fifth point, and this is the point that Lord Briggs was making about the dicta pointing in different directions, he notes that the dicta says that the court should not shrink from applying the fiction created by the deeming provision to the consequences which would inevitably flow from the fiction being real. And he quotes Lord Asquith in the famous East End Dwellings Company case, where Lord Asquith said, rather figuratively, the statute says that you must imagine a certain state of affairs. It does not say that having done so, you must cause or permit your imagination to boggle when it comes to the inevitable corollaries of that state of affairs. And we can see that that dicta of Lord Asquith in East End Dwellings was relied upon by the Court of Appeal, or at least the majority of the Court of Appeal in Fowler. and you can see there that Lord Justice Henderson in the Court of Appeal, having quoted that passage from East End Dwellings, then didn't let his mind boggle. And he says, what then is the state of affairs which section 15.2, that's the relevant deeming provision in our case, require us to imagine? Perhaps with hindsight, amusingly, he says, in my judgment, there can be no room for doubt about the answer to this question. I say amusingly because, of course, even at that stage, you had conflicting decisions of the FTT and the upper tribunal. And indeed, even in the Court of Appeal, the Court of Appeal was split. Anyway, so no room for doubt about the answer. It is that the relevant duties of Mr. Fowler's actual employment are instead to be treated for income tax purposes as the carrying on of a trade in the UK. Accordingly, in the imaginary world which we have to enter, the actual earnings of Mr. Fowler from his employment must instead be regarded as profits of the trade. It follows that this deemed trade is the only source for income tax purposes from which taxable income can arise to Mr. Fowler in respect of his relevant activities. So importantly, the majority in the Court of Appeal found that the effect of section 15 was to alter that source. So even though the income was derived from an employment, the effect of section 15 was to alter the meaning of employment for treaty purposes and supplied the meaning of employment in Article 15 so that Mr. Fowler fell outside Article 15. Now, you'll recall that when we were going through Lord Briggs's summary, I set out that there was a two-stage process. First, identifying the purpose of the provision, and then second, applying the deeming provision consistently with that purpose. I emphasise that because what Lord Justice Henderson and the majority in the Court of Appeal did is they dived straight into the second stage of applying the fiction. Nowhere in the majority's decision is there any examination of or identification of the purpose of the deeming provision that they were applying. And you'll see that that was significant because the Supreme Court started with that stage one exercise in terms of identifying what the purpose of section 15 of ITOIA was. And they started that by looking at what the FTT had found was the reason for the enactment of this deeming provision back in 1979. Now, again, there was some debate between the parties as to what that purpose or reason for the enactment back in 1979 was. And the reason why there was a bit of a debate was because there were potentially conflicting statements, first in the Hansard report of the debates, and secondly in the OTS review of tax reliefs, which was produced in March 2011. The taxpayer was relying on certain phrases that were used in the Hansard debate, which the Supreme Court noted were unclear, whereas the FTT had relied on the 2011 report of the Office for Taxation Simplification. And what was interesting was that even though that report post-dated the enactment by 30 years, the FTT still found that that OTS report was both admissible and also recorded the correct reason for the enactment. So before the Supreme Court, the taxpayer said, no, that's inadmissible. You can't rely on a report produced 30 years after the enactment for the purposes of identifying the purposes of the enactment. And the Supreme Court said, no, the FTT had been entitled to rely on the report because the report was recording what had happened at the time. So what was the purpose? As Colm has identified, the purpose of the introduction of this deeming provision was to availed divers of the more generous expenses regime, which was available to the self-employed. Importantly, the Supreme Court observed, its purpose was not to resolve any uncertainty about employment status. The Supreme Court then went to look at, before they looked at section 15.2, they looked at section 15.1, which provides or sets out the circumstances in which section 15.2 applies. And the Supreme Court noted that it only applies if there wasn't unemployment and that there was employment income for UK tax purposes. Moreover, the Supreme Court noted that in identifying what was unemployment or what was employment income in section 15.1, sections 4 and section 6 of ITIPA supplied the domestic tax law meaning for those terms in section 15.1. So that the question was, does section 15.2 alter the section 4 meaning definition of employment, which applies in section 15.1? So the Supreme Court looked at section 15.2, and you can see we've got it up on the screen. Section 15.2 of ITOIA provides the performance of the duties of employment is instead treated for income tax purposes as the carrying on of a trade in the United Kingdom. Interestingly, as you all know, ITOIA was produced as part of the tax law rewrite. And it's interesting to look at what the words were in the original enactment back in 1978, and that was in section 29.1. And you can see we have that on the slide. And that used slightly different language. The Income Tax Act shall have effect as if the performance by the person of those duties constituted the carrying on by him of a trade. So it didn't use the language of instead, it used the language of as if. Now, one leading commentator, and I think this is consistent with the judgment of Lord Justice Lewison, the minority in the Court of Appeal, has said that under that original enactment, the use of those words as if makes it clear that the deeming provision is not seeking to alter the source or alter the nature of the employment. Hence the words as if. But that leading commentator, John Avery Jones, says, however, one effect of the tax law rewrite, whether intentionally or more likely unintentionally, was by changing the wording to is instead, the effect was to change the effect so that under the new provisions, the section 15 provision, the effect was to alter the source, to alter the employment, so that the employment is replaced and is now a trade. The Supreme Court looked at this carefully. Lady Arden in particular was very interested in, well, what does is instead, what does it mean? And the conclusion they drew, we can see, we've set it out at paragraph 31, is on the slide. Section 15 is about the taxation of income arising from the performance of those duties of employment, but introduced by the word instead, provides that the income is to be taxed as if, contrary to the fact, it was profits of a trade. So the Supreme Court's conclusion was that in fact the use of the word instead was a synonym or was the same as, meant the same as if in the previous legislation. Now, as it happens, that conclusion is consistent with the explanatory note, which itself, that's the explanatory note to section 15.2 of ITOIA, which itself used that word or those words as if, and noted that it was based, the provision was based on the ITIPA equivalent. Just finally, I wanted to just look at one of their concluding remarks in the Supreme Court. You'll see that at paragraph 33, we have it on the slide, Lord Briggs, just standing back, said, if one asks, as is required, for what purposes and between whom is the fiction created, it is plainly not for the purpose of rendering a qualifying diver immune from tax in the UK, nor adjudicating between the UK and South Africa as the potential recipient of tax. Now, I think I would just perhaps strike a note of caution, because if one was to apply that reasoning to any deeming provision, really, I would suggest it's unlikely to be the position that many domestic deeming provisions are enacted with double taxation issues in mind or as their purpose. However, on any view, the Supreme Court, in construing and applying the deeming provision in Fowler, took a much narrower approach than that of the majority in the Court of Appeal. I think that the decision, the judgment, demonstrates the importance of first identifying the purpose of the deeming provision. The decision and the outcome, I think, reflects the limited purpose that Section 15 was enacted to address. And just finally, I'll just flag that as Colm says, the Supreme Court didn't address the meaning of the context otherwise requires, and so didn't address the argument, well, even if the domestic tax law meaning for employment was altered by Section 15, whether the let-out clause in Article 3T, 3.2, the context otherwise requires, whether that would apply to supplant that domestic tax law meaning. And when we come to look at some of the other deeming provisions to which these reasonings and principles might apply, I do think that one has to always still bear in mind whether that get out in Article 3.2 might be of application. I'll hand over to Colm.
Thank you. So the last thing we're going to look at is the implications that the Supreme Court's decision might have for other deeming provisions and how they interact with double taxation treaties. But before I come on to show you what I'm going to slightly speculate about, there's an interesting nugget in the decision of the Upper Tribunal by Mr. Justice Marcus Smith, because he posited a hypothetical to counsel for the taxpayer and the revenue during the hearing, where he asked what would be the situation if Section 4 of ITIPA, which you'll recall has that domestic meaning of employment, what if Section 4 had a deeming provision which said that all contracts for service, so self-employment, were deemed to be contracts of service, so employment? Would that mean that for treaty purposes, all of those contracts for services were employment? And the revenue said that that would be so fundamentally at variance with the scheme contained in Article 7 and 14 on business profits and income from employment that it couldn't supply the meaning of the term employment, whereas the taxpayer said it would. And then Marcus Smith went on to say this, which he did preface by saying he was expressly not deciding the point. So this is entirely arbiter, but nevertheless very interesting. And he would say, in response to his example about deeming the self-employed to all be employed, I should say that I do not necessarily consider that more narrowly drawn deeming provisions, whether adding to or subtracting from the meaning of employment in Section 4, would be incapable of supplying Article 3.2, the meaning of employment for the purposes of Article 14, even if they deem something that is employment not to be something that is employment. I'm sorry, I'm garbling the end of the sentence, but you get what I mean. So it does make sure that this issue of deemings and their impact on DTAs is very much alive. So I'm going to look at a few examples where you might want to think about this. And I don't think in any of them is there an entirely clear answer, but they're nevertheless, I think, profitable to think about because it allows one to think about how you apply Fowler. So the first example is, and I should say, I've picked a few examples that occurred to me. I'm sure ITIPA is littered with them. But these are all going to scenarios where you don't have a situation where there are wages, salary, or other similar remuneration, which is the term used in the employment income article. But you might think that there is a domestic deeming which might bring you within that, such that that article is the relevant one to allocate taxing rights. So if you had a non-resident person acting in the UK and deriving income in the UK, does this then mean that the UK would get taxing rights? So the first example is agency workers. And this is quite a striking example. The language used in section 44 is that agency workers who meet certain conditions but who aren't actually employed by agencies are treated for income tax purposes as holding an employment with the agency. So query whether that means that for DTA purposes, in Article 15, agency workers who in the real world are self-employed are deemed to be employees. Does that then feed through to Article 3.2 and supply the meaning of employment for DTA purposes? Perhaps. It's possibly one of the most interesting examples in ITIPA. Another thing everyone will be familiar with, I anticipate, is IR35. And I think this is a lot more confused. But you will all recall that IR35 taxes a hypothetical deemed direct payment in a case where someone is using a personal service company to avoid a scenario where they would otherwise be employed if they were directly engaged by the person to whom the personal service company is supplying their services. And if you look at the section, the chapter that currently applies only to public authorities, but from April next year will apply to medium and large private sector engagers as well, you get section 61R. And in that, there are several references to deeming. For instance, they say that the income tax acts apply as if the worker were employed by the person treated as making the deemed direct payment. And that's whoever is making a payment to the PSC. And there are other deeming provisions contained within that section as well. However, I think it pays careful reading because it begins by saying that it is effectively in relation to this deemed direct payment. So people often refer to the effect of IR35 as creating deemed employment. I don't think that's quite accurate. But could you say if you had a non-resident worker and a non-resident personal service company, the income of that personal service company and its profits, we know from Article 7 that that will be taxed in the country of which the personal service company is resident. If the revenue is serving that PSC with Regulation 80 determinations and Section 8 decisions and says, we are now taxing you under IR35, can the company respond by saying, no, what you're in fact trying to do is taxing my business profits? And we know that the model convention and potentially the actual treaty allocates that right to a different country. Could the revenue riposte by saying, well, in fact, what actually happens is that Section 61R deems you to be employed and to be getting employment income? Possibly the answer is neither, because what isn't happening in the R35 legislation is that the income and profits of the PSC are being recharacterized as something other than they are. What in fact happens is you have this hypothetical construct of a deemed direct payment, which is based on a further construct, which is called a chain payment, which is based on money paid to the PSC in respect of the workers' services. You then deduct various items from that, add various items back on, perform various calculations, and then you come up with a deemed direct payment, and that's what's charged to tax. So it's not really that the profits of the business are being recharacterized. So I think that's probably a weaker example where anyone might suggest that there is some form of deemed employment or deemed employment income here. But let's look at two scenarios where you certainly have employment, but you have items that are treated as employment income. And again, the reason this is interesting is because the DTA allocates taxing rights in the employment articles in respect of wages, salaries, or other similar remuneration. So broadly what we would think of as earnings. But of course, we know that in ITIPA, there are lots of things that fall outside of Section 62, but you are nevertheless taxed as employment income. So an example here are cheap loans. If an employer makes a loan of more than £10,000 to an employee at below the official interest rate, broadly, they're going to be taxed on the difference between the interest they do pay and what the official interest rate is. That benefit is an amount treated as earnings, and it is treated as earnings from the employee's employment. So we know domestically that Section 27 tells us this counts as general earnings and is taxable irrespective of whether the employee was non-resident. But query how that might fit with the model convention, because the model convention applies only to wages, salaries, or other similar remuneration and allows you to tax those in the country in which they arise. Other payments, which aren't expressly dealt with in the convention, are taxed in the country of the residence of the person receiving them. So if you had a non-resident employee working in the UK, query why it is that the benefit of a cheap loan, which isn't wages, salaries, or remuneration, has a right to be taxed in the UK. The answer may be that you should always go and look at your particular treaty, because what the OECD model lacks, but what, for instance, the South African treaty does have, is a get-out clause in the bottom of the other income article, which I've just spoken about, which says that the country in which the payment arises may tax it, even if it is paid to an employee resident in a different country. And it's worth noting that is a may provision. So it doesn't mean that the other country can't tax it as well, just that the UK can. So then it'll be up to those countries to decide between themselves, potentially through a MAP procedure, how they're going to give relief. Another example, which is more interesting than the cheap loans because it is not general earnings, so there is no automatic claim in ITIPA to tax this, are termination payments. So imagine a termination payment which is substantially to do with an injury to feelings award in a discrimination claim arising from termination. So arising from termination supplies that connection to section 403 and connects the payment there. Because it's not pay in lieu of notice or anything like that, it's not treated as earnings. And importantly, termination payments and everything in parts 6, 7, and 7A, they aren't treated as general earnings, though they are treated as employment income. So the question of who taxes them is open and would normally be determined by the DTA. So if you had a payment made to a non-resident employee who was exercising an employment in the UK, we know that that payment counts as employment income. Now, is that enough to transform that employment income into wages, salaries, or other remuneration so that that article allocates taxing rights and allocates the taxing rights to the UK? Or does it still not have the character of wages, salaries, or the remuneration? So it's an other payment and potentially taxable in the other country. And it's a bit of an open question, but I don't think that saying something counts as employment income goes so far as to tell you that it is wages, salaries, or other remuneration. If you go and look in section 7 towards the top, you'll see that there are references to wages and salaries in the definition of employment income, but employment income is a broader term than just that. So I'm not sure it's as obvious that something that looks like a deeming provision in section 403 telling you that these payments count as employment income are enough to tell you that they therefore count as something like wages, salaries, or other remuneration, and that means the UK gets taxing rights. And there is an example of this argument succeeding in a case called Resolute Management, which Akash did, I think, in 2008, quite some years ago now, where an ex gratia termination payment was made to an American who had been working here but resident in the US, and she did succeed in showing that this fell within the other payments article of the relevant treaty. And so it was allocated, taxing rights were allocated to the US. And the issue didn't quite arise as I'm putting it, but that is something that's quite possible for taxing rights in respect of termination payments for employments that happen in the UK, not to be taxed in the UK. As I said at the beginning, there are probably lots more deeming provisions in ITIPA that one can look at, and in all of them, you have to start considering their purpose. Now, we've seen what the Supreme Court has said in Fowler. As Akash has said, it's probably never going to be the case that if you investigate the purpose of any of these provisions, that they have as their historical background the intention to allocate taxing rights between different states. But it is quite important when you're trying to understand their scope. And is this trying to create an actual employee for tax purposes, or is this just trying to change the way income is taxed, as was the case for Mr. Fowler? So with that, I'm going to stop sharing and just hand you over to Akash to wrap up and deal with anything else that might have arisen while I was talking.
Thank you, Colm. Well, we've got no questions, and so it just remains me to say first that we will circulate this slide deck with our feedback forms, and secondly to thank you for joining us throughout these lockdown 11s. We hope you've enjoyed them, found them interesting, and we look forward to resuming in September. Bye-bye.
I hope.